attempted ag murders, kidnapping, attempted ag burglary.
Deputy Shaw did read me his Miranda rights.
She raises the gun and fires into Ryan Poston's twitching body until she fired the final shot.
And he shot a 24-year-old man in the face. The man did die.
Andrew Romero, a career criminal with a long history of violence, faced sentencing after violating his probation tied to earlier robbery and firearms charges.
He understands the allegations.
Prosecutors painted a grim picture of Romero's past, detailing crimes that showcased his repeated use of guns and reckless behavior. Among his offenses, Romero was accused of shooting a 24-year-old man in the face, resulting in the man's death.
He shot a 24-year-old man in the face. The man did die.
In another incident, he used boys to assist in shoplifting.
He uses a child, there was 3 children actually, I'm not sure if they were his, to shoplift from Walmart.
He later threatened a store clerk with a gun while attempting to steal gas.
He pointed a gun at the clerk while attempting to steal gas.
Adding to his list of crimes, Romero remains the prime suspect in the murder of Rio Rancho officer Greg Benner. The officer was ambushed and killed during a Memorial Day traffic stop, a crime that shocked the community. In court, Officer Benner's widow pleaded for the harshest punishment, stating,
"Please give him the maximum sentence for this parole violation. There should be no way that he should be walk the streets again."
The judge agreed with the prosecution and the victim's family, sentencing Romero to 11.5 years in prison, the maximum allowed for his probation violations. Regarding murdering Rio Rancho police officer Greg Benner in May 2015, Romero was sentenced to life imprisonment without the possibility of parole. In addition to the life sentence, Judge George Eichwald imposed an extra 23 years for related offenses, including tampering with evidence and shooting from a vehicle. Romero's then-girlfriend, Tabitha Littles, who was present during the incident, received a 16-year prison sentence after pleading guilty to charges of conspiracy to commit armed robbery and harboring a felon. Her sentence could be reduced by half for good behavior. In December 2018, the New Mexico Supreme Court upheld Romero's life sentence, rejecting his appeal that claimed the jury pool was tainted due to extensive media coverage. In a case that shook the community of Hamilton, Tony Petite pleaded guilty to 2 counts of aggravated murder for his role in a deadly drive-by shooting in August 2016. The attack claimed the lives of Orlando Gilbert and Todd Barus, and was believed to be a retaliation for an earlier shooting at Double's nightclub, which had left 1 person dead. Prosecutors revealed that Petite, along with Michael Grievous, Melinda Gibby, and Zachary Harris, had been hired to carry out the attack. On the day of the shooting, Petite fired an AK-47 into a Ford Mustang, killing Gilbert, the intended target, and Barus, who was caught in the fire.
I think about precious little Thea, Todd's beautiful baby girl that will never get to know her daddy. Todd would have been a good father, but because of you, he will never get that opportunity, and he will never see his little girl grow up.
Todd Barris's mother described the devastation caused by his loss, calling it life-altering for their family in a letter that the prosecutor read.
"Todd was my firstborn and my only son, and you took him away from me, his sisters, his nephew, his daughter, and all of his friends and family. Because of you and your actions, our lives have been destroyed."
But Tony, you can look at the judge who holds your fate to your freedom, but you can't look at the family members of those you harmed. My wife just wants you to look at her.
Orlando Gilbert's father, Leroy Brown, urged Petite to face the families whose lives he had shattered. After an emotional pause, Petite turned to look at the grieving families, visibly holding back tears.
Can you just look at them, Tony? Look at them. Those are the people whose lives you affected.
As part of a plea agreement, Petite was sentenced to life in prison, avoiding the death penalty. His co-defendants have also faced justice. Zachary Harris is serving life without parole after his guilty plea. Gibby also pleaded guilty to aggravated murder and agreed to a sentence of 30 years to life, with formal sentencing pending her cooperation in the trials of others involved. Grievous, the mastermind behind the retaliation, was found guilty of aggravated murder and is serving a life sentence. Shayna Hubers was found guilty of murder for the second time in the shooting death of her on and off boyfriend, Ryan Poston. The jury deliberated for 5 hours, reaching the same conclusion as in her first trial. Hubers intentionally killed Poston in his Highland Heights condo on October 12, 2012.
We, the jury, find the defendant, Shayna Hubers, guilty of murder under instruction number 5.
During the trial, Hubers' defense argued that the killing was self-defense, claiming Poston had verbally and emotionally abused her. They painted a picture of a toxic relationship where Hubers was subjected to cruel remarks and degrading treatment.
Calling her an effing hillbilly, that she's crazy, that she's deranged, degrading her education, where she went to school, degrading what her plans were for the future as a school counselor, degrading her own self-worth. I can't love you, no one can love you, you can't work because you were touched as a child, and no one will ever love you.
However, the prosecution countered that Hubers' actions were calculated, stating she shot Poston out of anger because he was planning to end their relationship.
3 more times, she raises the gun and fires into Ryan Poston's twitching body until she fired the final shot where she knew it would kill him.
The jury had the option to consider lesser charges, such as manslaughter or reckless homicide, but they firmly rejected those alternatives. Instead, they delivered a clear verdict: murder. In her first trial, Hubers was sentenced to 40 years, but that verdict was overturned after it was revealed that one of the jurors had a prior undisclosed criminal conviction. But this time, Shayna Hubers was sentenced to a life sentence at the Kentucky Correctional Institution for Women. She will be eligible for parole in 2032. Brett Owens, the man accused of a string of crimes in Union Township, Clermont County, remains at the center of an ongoing case that began earlier this year. Owens faced a 9-count indictment.
Attempted ag murders, murder, kidnapping, kidnapping, felonious assault, tampering with evidence, attempted ag burglary, and attempted burglary.
These charges stemmed from a series of incidents starting on February 18, 2024, when neighbors reported alarming activity involving Owens.
Neighbors had actually called, said one of their neighbors was on their porch. He had a firearm in his hand.
According to prosecutors, Owens tried to force his way into a neighbor's home while armed before fleeing the scene in an SUV. He was later arrested at Cincinnati Northern Kentucky International Airport, CVG. During questioning, Owens reportedly admitted to shooting his wife, claiming she was inside their home at the time of the incident. Police later found the victim with shot wounds lying inside the house.
At that point, he finally told them that he had shot his wife and she was inside the home. This was 1 hour later. His wife had been laying there in the home.
Owens appeared in court for a bond hearing where his erratic outbursts led to his removal from the courtroom. Despite efforts from the judge to maintain order, Owens continued to make incriminating statements, asserting that he believed his wife was attempting to drug him.
Give me a thermal with chicken noodle soup. I think there was something in it.
His erratic behavior highlighted ongoing concerns about his mental state. A judge later deemed him competent to stand trial, and Owens pleaded not guilty to all charges.
Then they put this thing in my chest. There's a scar that Anderson Mercy put in my chest. And it basically programmed me to do this to.
He was removed from courtroom because of his behavior.
No, it's the truth.
This is not
That's
in
the
your-
truth. Deputy Shaw didn't read his Miranda rights. Deputy Shaw didn't read me his Miranda rights.
The severity of the accusations led the judge to issue a $1 million bond. If convicted on all counts, Owens could face a maximum sentence of 45 years in prison. Angelique Nash, initially convicted of murder in 2013 for her role as a lookout during a 2010 burglary that resulted in the death of 81-year-old Dorothy Session, has seen a complex legal journey unfold. Session was brutally beaten in her Bakersfield home by David Moses, while sisters Catila Nash and Angelique Nash participated in the burglary. Though Angelique never physically harmed the victim, she was sentenced to life in prison under the felony murder rule, which held her accountable for her role in the crime. In 2019, the introduction of SB 1437 amended California's felony murder rule, requiring that a person must actively commit, intend to commit, or aid in a killing to be charged with murder. Nash petitioned for her conviction to be dismissed under the new law. However, her motion was initially denied when a Kern County judge ruled SB 1437 unconstitutional, marking the second time a Kern judge rejected the law. Prosecutors at the time argued that overturning her conviction conflicted with voter passed Proposition 7, which supported life sentences for participants in crimes leading to someone's death.
The law taking people who are rightfully convicted of murder and simply wiping away a murder conviction because the legislature decided to change their mind in direct conflict with what the people had directly put into place.
The legal tide shifted after an appellate court declared SB 1437 constitutional and remanded Nash's case for reconsideration. Her murder conviction was vacated, and in 2021, she was resentenced for first-degree burglary. With credit for time served, Nash was released. However, in January 2023, the 5th District Court of Appeal discovered a procedural oversight. The trial judge had not formally vacated the murder conviction during resentencing. The case has since been remanded to Kern County to correct this formality. Once the conviction is formally vacated, the case will proceed to juvenile court to determine the appropriate jurisdiction and any additional legal proceedings. In April 2020, tragedy struck a family in Lemon Grove, California, when Dwayne Groves Jr., the ex-boyfriend of Joanne Hoyt, entered her home and shot twin sisters Leah and Kyra Christopher and attempted to kill their older brother. Leah and Kyra were bright, promising students at Helix High School, excited about celebrating their birthday and achieving milestones like graduating high school. Their mother, Joanne Hoyt, gave an emotional statement during the sentencing, recounting the devastation Groves brought to her family. Her voice trembled as she described the trauma her family still endure after witnessing the horrific murders.
I believe the defendant knew my daughters had a bright future ahead, and that is the reason he took their lives. He was jealous of the adults they were going to become. He was jealous of the mother I was. I think his jealousy stemmed from his own childhood trauma and neglect.
She spoke directly to her surviving son in court, apologizing for not being able to protect him and expressing regret for allowing Groves into their lives. The pandemic compounded their grief, preventing the family from holding a proper burial for Leah and Kyra, with restrictions allowing only 10 people to attend.
When we buried the twins, no one could attend. It was at the beginning of the pandemic. Due to lockdowns and restrictions, only 10 people were allowed. He stole everyone's ability to find closure that day. He stole everyone's abilities to say goodbye.
Groves showed brief moments of visible emotion during the hearing, but remained silent. His guilty plea spared the family a trial, though it did little to ease the pain left in his wake. In the end, Dwayne Groves Jr. was sentenced to life in prison without the possibility of parole, along with an additional 72 years to life. The sentencing ensures that Groves will never walk free, bringing a measure of justice to the grieving family, though nothing can replace the lives of Leah and Kyra. A Massachusetts jury has found Joshua Silva, 38, guilty of the murder of 69-year-old Joyce Howland, a retired teacher from Fairhaven.
What do you say, sir? Is he guilty or not guilty?
Guilty.
Guilty of what, sir?
Guilty of murder of the first degree.
By what theory or theories, sir?
Two of them, extreme atrocity and cruelty.
The tragic incident occurred in October 2013, when Silva, working as part of a home repair crew at Howland's residence, committed the crime after stealing her jewelry, which he later attempted to pawn for drug money. Prosecutors argued that Silva's actions were motivated by desperation, and the jury agreed, convicting him under two legal theories: extreme atrocity and cruelty, and felony murder during the commission of an armed robbery.
Very pleased. She deserves some justice and some peace.
Throughout the trial, Howland's close friends attended every session, supporting her memory in the absence of immediate family. Jan Beals, one of her closest friends, shared her relief.
Every night going to sleep and thinking of her, that picture of her dead was no fun. We'll never do that to someone else.
Another friend, Sylvia Collette, recalled the devastation of realizing Joyce was gone and expressed hope that no one else would suffer at Silva's hands.
She can rest in peace now that all her friends were right by her side, through thick and thin, to get this done and get this guy behind bars for good.
Silva, who remained composed as the verdict was read, will serve life in prison without the possibility of parole, the mandatory sentence for first-degree murder in Massachusetts. He will carry out his sentence at MC Wine Cedar Junction in Walpole. Reflecting on the outcome, Howland's friends expressed gratitude, saying she can finally rest in peace. Antonio Miller has been held accountable for a devastating crime that tore apart an Akron family. The tragic events unfolded on April 7, 2022, when a 50-year-old mother was found fatally shot in her car. The killing occurred just days after Miller had broken off his relationship with the victim's daughter. During the investigation, prosecutors revealed their belief that Miller may not have acted alone, though no additional arrests have been made. In court, the victim's family confronted Miller with powerful words, expressing their grief and resolve. One family member stated,
"So after today, we won't cry anymore. It's just gonna be happiness, because that's what my mom would want for us, is to move forward, get her justice, and to see you rot in jail."
The victim's family also poured their emotions into letters, which were read aloud during the sentencing. Their words reflected the depth of their loss and the lasting pain the family continues to endure. At the conclusion of the hearing, Antonio Miller was sentenced to life in prison with the possibility of parole after 30 years. The decision provided the family with a sense of justice and the hope to begin healing after such an unimaginable loss. In a tragic case that unfolded over years, Natasha Stewart, also known as Pebbles Da Model, was held accountable for her role in the death of Karima Gordon.
I told her, I said, "You're gonna be the next hot model," and she was just so excited.
She claimed that they were friends.
Pictures, and she was asking me a lot about being in the magazines and the videos and the photo shoots, and we was talking a lot about the modeling industry, and I was just telling her about a lot of that.
The events began in March 2012 when Stewart referred Gordon, a resident of Atlanta, to Tracy Lynn Garner for illegal silicone buttocks injections. Stewart accepted $200 for the referral and falsely claimed Garner was a licensed nurse.
I motivate my sisters. That's what I do. I motivate all my sisters, my women. And that's one of the reasons why me and Karima, she felt comfortable with talking to me about certain.
Gordon, seeking the cosmetic procedure, suffered fatal complications just days after receiving the injections. The devastating outcome underscored the dangers of unlicensed medical procedures. During her trial, Stewart testified that she genuinely believed Garner was a qualified nurse. She explained that she had undergone the same injections herself more than 20 times without issue. Despite her claims, a Hinds County jury found Stewart guilty of culpable negligence manslaughter and conspiracy to commit manslaughter after 4 hours of deliberation. At sentencing, Stewart expressed deep remorse. The court handed down a sentence of 7 years in prison with an additional 8 years suspended and 5 years of probation. However, in 2016, the Mississippi Court of Appeals overturned Stewart's manslaughter conviction. The court ruled there was insufficient evidence to prove Stewart acted with reckless disregard for human life. They emphasized that Stewart's belief in Garner's qualifications, based on her own experience, indicated a lack of intent or awareness of harm. The defendant faced a series of charges stemming from multiple incidents involving assault, evading arrest, and interfering with police duties. These cases, spanning several years, involved different complainants, including family members such as the defendant's mother, sister, and an ex-partner, as well as law enforcement officers.
I admonished him that if he picks up a new case, violates conditions, I'm going to go absolutely nuts on the bond.
I'm completely fine with that, Judge.
So,
Leave it at that?
until
Okay.
we'll see.
We'll just leave it at that?
Sure.
Okay, thank you, Judge.
Mr. Roberts Clay, how's jail? It's been a long time since I've had someone with this kind of drama. Let's go through your spiel. 9/25/24, evading arrest, and you pick up an FSGI. 11/9/24, assault of a family member, assault of a family member, assault of a family member, assault of a peace officer, assault of a peace officer. You get on bond, I guess, he's on bond for all those cases, right?
Yes, Judge, I see.
And now you've picked up another assault of a family member and an interference.
The court reviewed the defendant's record, which included several instances of assault against family members and law enforcement. Some charges were relatively recent, while others dated back to 2022 but had only recently been filed.
Those were 2Bs filed, Judge, while he was in custody. So he was not out of custody. He's been in custody.
So in our case here, from November 9th, he has three assaults, and then he also has the FSGI in evading, the new assault and the interference that was filed on 11/13. Was that?
From 2022.
So they're older.
They're older ones that they just filed a couple days ago, but he's been in custody on our 3 assaults and the felonies.
So the felony assault, I see that he has not made bond on.
No, and that's why he was in custody, because he was on those 2 bonds while they filed these 2s on him.
Yeah, 22. And the interference was also from 22. Do you know all the assault family members, are they against the same complaining witness?
No, they're different, Judge. 2022 is Asia Barrows.
What is that, a girlfriend?
An ex-girlfriend.
An ex-girlfriend, okay.
No,
And then,
it's just regular, no baby.
okay, so then the other 3 assaults that we have here,
The other 3, the newer 3 are baby mama, mother and sister.
his mother?
His mother and his sister.
During the hearing, it was noted that the defendant had been released on bond for prior cases when new charges were filed. These included additional allegations of assault and interference. The defendant's failure to adhere to bond conditions became a focal point, raising questions about his ability to comply with court orders.
Mr. Roberts Clay, I want you to understand something, that I'm ordering you as a condition of your bond not to have any contact with any of the complaining witness in any of these cases. Do you understand? I'm also ordering you not to be in possession of any weapons, not to consume alcohol or illegal drugs. I'm going to randomly test you, and I'm going to put a GPS monitor, and I'm giving you 1,000 feet. I'm going to give you a 1,000 feet distance of where I don't want you to have contact with any of these people, any of the baby mamas, your mom, whoever else is part of these, the peace officers, anyone in any of these cases. Don't have contact with them. Don't go within 1,000 feet of where they live or where they work. There should be orders for protection on each one of these cases. So you have to understand, if you violate these, then the state can and will file additional charges against you. You need to understand, if multiple assault family members within a certain amount of time, they can hit you with 3rd-degree felonies, and you can be looking at 2 to 10 of the penitentiary on those. So I don't know if you're going to get out, but if you do get out, I would be very careful where you go, because even if you have whatever contact, they can file more charges on you. I mean, you've got now 1, 2, 3, 4, 5, 6, 7, 8, 9 open cases. Shreya, the evading arrest and interference on all these assaults, those happened after.
Yes.
Right, so I'm revoking the bonds on those two cases. The evading arrest and interference, the FSGI and evading, I'm revoking those bonds because of all the new cases that he's picked up.
I understand, Judge, but the two new cases are from 2022.
That's why I'm not doing anything with those, right? So I'm not using those against him to revoke the bond, but the new cases from 11-9, those are after, we ordered him follow conditions. You have failed to follow those conditions by picking up another case, another 1, 2, 3, 4, 5 assaults. So because you picked up those 5 assaults, I'm revoking the bond on the FSGI and evading.
So Judge, is this his first court date since the November 9th?
Correct. Yeah, this is the first time that I've seen Mr. Roberts Clay. I have not seen him at all, but we've been literally rolling him day for day to try to get him here. And we had Marco Sapien representing him, trying to get Mr. Clay, Roberts Clay and Marco at the same time so that's why. Did you want to add anything?
What are the conditions currently, Judge?
So no contact, no weapons, GPS, no going within 1,000 feet of any of the complaining witness where they live or where they work.
I'm satisfied with that, Judge.
Sorry?
That works, Judge.
And then I'm revoking his bonds on the FSGI and evading, and then that's it. So
What are you setting those at, Judge?
I think there should also be, I would ask that they also be set at 5,000, Judge, to mirror the others.
75.
5,000, Judge.
Oh, yeah, I was going to do 5,000 and 1, 2, 3, 5,005 on the FSGI and evading. And then I'll leave the others as is.
The judge imposed stringent bond conditions to ensure accountability and public safety. The defendant was ordered to have no contact with any complainants and to maintain a distance of at least 1,000 feet from their homes and workplaces. A GPS monitor was mandated, along with random drug and alcohol testing. The defendant was also prohibited from possessing weapons or consuming alcohol or illegal substances. These measures were designed to prevent further incidents and safeguard those involved in the cases. Due to the severity of the situation, the judge revoked bonds on 2 earlier cases involving evading arrest and interference with police duties. These revocations were based on the defendant's failure to comply with previous conditions and the filing of new charges. Bonds for the remaining cases were set at $5,000 each, consistent with prior amounts. The judge delivered a clear warning to the defendant, emphasizing the importance of adhering to all legal obligations. He cautioned that repeated offenses or violations of bond conditions could result in harsher consequences, including potential felony charges that carried significant prison time. The hearing concluded with instructions for the defendant to prepare for upcoming court dates and comply with all imposed conditions. The judge underscored the gravity of the situation, urging the defendant to take the matter seriously and avoid further legal trouble. The court convened to address a bond violation involving the defendant, who had been accused of substance use while under court supervision. The defendant's attorney and father were present, both emphasizing their respective efforts to address the defendant's issues. The session unfolded as a candid discussion about accountability and the defendant's lack of progress in seeking treatment for his addiction.
In order to try. Well, let's get clear, Mr. Rivers. I mean, just so that it's clear. On November 6th, he tested, there's the THC that's in there, and I don't know whether he has a medical marijuana card. He does have a medical marijuana card. The problem doesn't become that, it becomes the cocaine.
Mm-hmm.
And then, so then it disappears from his system, which it normally would if he's not using or if we don't catch him on the right date in terms of testing. But then, almost exactly a month later,
he was positive
again for cocaine.
I have discussed with him getting an intake to determine whether or not what kind of services he could use going forward. I've discussed with him, and
has he been in treatment before?
He has done treatment before. He had brought up Lincoln Behavioral Services. He was going to get in contact with them. His father is here today. I've also gone over that information with him. I think the idea is to get that intake here over the next week or so.
Well, why wasn't it done before? Why isn't, I mean, when it hits in November, and I'm sure he was using before then, why didn't he do something then?
Well, I wasn't in receipt of any violation reports until yesterday.
Right, but he knows he's using. So why hasn't he done something before then, is my question.
The hearing began with a review of the defendant's recent positive drug tests, which included THC and cocaine. Despite having a medical marijuana card, the judge expressed concern over the cocaine use, highlighting that it was a recurring issue. The judge questioned why the defendant had not sought treatment earlier, particularly after the initial violations, and noted that his lack of initiative was troubling. The defendant's father spoke earnestly, explaining his attempts to help his son.
His father, my name is Daniel Woodville. He reached out to me and asked me if I could, help him with this problem. And, he's trying. So I'm just trying to support him in any way that I can. He's working for me. He's got 4 kids, and just trying to do. I'm trying to help him, to get off the drugs and to do the right thing. He's been working with me since Sunday night. We've been up all night working on a small construction company. And I'm just trying to keep him busy and trying to keep him away from, the people that he's.
I don't doubt your sincerity in doing what you're doing. I mean, as a dad, I mean, and I get you standing up because you're trying to figure out what you can do to make it right.
Yes, sir.
All right. The problem is he's got to make that decision. And I don't think that he has, through your best efforts. I don't think that he has. And the problem for you is that you can keep doing it. You can keep doing those things, like you said, keeping him busy doing this. But if he hasn't decided that that's what he's going to do,
Well,
it won't happen.
Well, Your Honor, I think he has, because him and I hasn't talked for months, and he's reached out to me. We had a bad falling out about this, and over the last couple of weeks, like I said, we haven't talked for months. So I think I do see him coming around. I'm not trying to mislead you or anything.
No, I don't think that you are, sir. I mean, what I'm listening to is the faith of a father. That's what I'm hearing. And that, I don't have any doubt in. What you're telling me, I have no doubt in any of that. What I have doubts about is really what he wants to do. Okay? Because when I see testing like this, that's somebody that's gonna kind of give you lip service, but isn't gonna quite do the work.
He detailed how he had engaged the defendant in work and other activities to keep him focused and away from negative influences. The father acknowledged their past conflicts over the defendant's substance use, but emphasized that his son had recently reached out for help, which he interpreted as a positive step. The judge, while empathetic, emphasized that true change must come from the defendant himself.
Because, young man, you're not set up in any treatment, are you?
No, sir.
Did you ask your attorney or anybody else to try to help you get set up in treatment?
No, sir. I'm taking.
What efforts have you made to try to get into treatment?
There was a step this morning, Your Honor.
Pardon?
There was a step this morning. We did discuss going into a treatment facility and getting an intake.
Oh, I get that this morning, right? But the test was a week ago, and he probably used before that test actually happened. The test was on the 6th. And nothing. His dad's been trying to do what he can do with him. Nothing. And it's not until he gets here this morning and he's facing something that he decides that I'll say whatever.
We talked about, we did talk about treatment. He said he'd be willing to.
Right. I'm not doubting any, sir, understand what I'm getting at. I'm not doubting any of that. What I'm saying is, I can say I'm gonna walk from here to there. Until I take that first step, I haven't done anything.
Yes, sir. Yes, sir. I'm not going to keep manipulating me or the court. He doesn't know I'm done with him. You know, that's why we had to fall out. I told him I'm not going to be associated with this nonsense. And if he doesn't, you know.
But get this, sir.
Yes, sir.
And it's not your own fault.
I'm sorry.
It's not your fault.
Oh, yes, sir.
But what I'm saying is he's manipulating already. The only reason he has those conversations that he's having, and then the conversation this morning, is because he's caught. And he's still, although having those conversations, he gets here this morning, between then and now, hasn't done anything. Hasn't made that step. Then he gets here this morning.
Excuse me. Can I talk?
Yeah, go ahead.
What are you gonna say? I made a step by coming. A big one.
Oh, I know. But what I'm saying is that step.
I got here, I got right up, came to court.
But sir, listen. The choice on that is, yeah, you don't come today, you're gonna get a warrant, I'm gonna get you.
Right.
So that's just the cold-hearted reality of that. Okay, so I don't know how much of a step that is. If you think the step of walking in here knowing that you're facing a violation is tough, that's why you haven't done anything for treatment, because that's a tougher step. That's why you haven't done anything. And you will say and do anything not to do that. I've been dealing with addicts for a long time. Some of it your fault, some of it not your fault.
When asked about his efforts to seek treatment, the defendant admitted he had not taken significant steps. Although there was a recent discussion about entering a program, it had only occurred recently, and no tangible actions had been taken prior to the hearing. The judge expressed skepticism, noting that the defendant's sudden willingness to discuss treatment seemed more motivated by the immediate consequences of his actions rather than genuine commitment.
At this time, I don't know if the court's going to remand him, whether they're going to.
Here's what I'm going to do. He wants to make a step. He's going to tell me that he's doing it. He's trying to tell his dad that he's doing it. He's talking the game and not doing it. I am going to revoke his bond. I'm going to remand him. I'm going to set it for December 26th. In between then, there are individuals at the jail that can work on inpatient. He can work on inpatient with you to try to get him into a program. I will sign virtually any order if he will get himself into treatment. Because the cold-hearted reality is, as hard as dad tries, as hard as everybody else is trying, one day somebody's going to wake up, this young man's not going to be alive. And then nobody's going to have another shot at it. I've seen it happen too many times.
Thank you, Your Honor. This will be adjourned to a PCC the 26th.
On the 26th, I'll adjourn this matter to December 26, 2024, 9 a.m. Defendant's bond at this time is revoked. And Mr. Drukas, if we get something, I'll consider release if we get something in place.
I'll keep it done.
The defense attorney acknowledged the need for immediate action and proposed working with treatment facilities to find a suitable program for the defendant. The judge agreed, emphasizing the urgency of addressing the addiction to prevent further deterioration of the defendant's life. Ultimately, the judge decided to revoke the defendant's bond, stating that remaining out of custody without taking action was not an option. The court scheduled a follow-up hearing, during which progress toward entering a treatment program would be reviewed. The judge assured the defendant and his family that any legitimate effort to enroll in rehabilitation would be supported and facilitated by the court. The hearing ended with the judge expressing hope that the defendant would use this opportunity to commit to meaningful change. The consequences of inaction were starkly outlined, with the judge stressing that this could be the defendant's last chance to turn his life around. The message was clear. The path to recovery required immediate and genuine effort. Ghislaine Street Michelle, a 38-year-old chiropractor and mother of 2, also shared her journey during the Idaho abortion trial, shedding light on the personal challenges posed by restrictive reproductive health care laws. Married for 8 years, Ghislaine and her husband had built a happy family with their daughter and son. However, between these 2 pregnancies, they experienced a heartbreaking loss during their second pregnancy, which deeply affected their family.
What do you do for work?
I'm a chiropractor.
And did you go to school for that?
I did.
What degree did you receive?
My degree is as a chiropractic physician or a doctor of chiropractic.
Do you have any additional licenses?
Just my chiropractic physician's license.
Are you married?
I am.
How long have you been married?
We've been married for 8 years.
I'd like to discuss your history of pregnancies. Do you have children?
I do. I have 2 children.
How old are they?
My daughter is almost 4, and I've got a 10-month-old son.
And in addition to those 2 pregnancies for those 2 children, have you had any other pregnancies?
I have had 1 other pregnancy between those 2.
So 3 in total?
That's correct.
Okay, let's go through those one by one. For your first pregnancy, can you tell us the date you first found out you were pregnant for the first time?
The exact date, I'm not sure, but it was around April of 2020.
And was your first pregnancy a planned pregnancy?
It was, yes.
How would you describe the course of your first pregnancy?
Thankfully, that pregnancy went as planned, no complications, and we delivered a healthy baby girl at the end.
In mid-2022, Ghislaine became pregnant for second time, a planned and eagerly awaited addition to their family. Early medical checkups showed no complications, and the couple was thrilled to expand their family. However, at the 20-week anatomy scan, they received difficult news. Doctors identified a series of significant developmental concerns, including issues with the spine, heart, lungs, and limbs. These conditions meant that the unborn's growth and survival would face insurmountable challenges, and the pregnancy was unlikely to progress in a way that would allow a life after birth.
Let's discuss your second pregnancy. When did you find out you were pregnant for the second time?
That was around July of 2022.
And was your second pregnancy planned?
It was, yes.
How far along were you when you found out you were pregnant?
I had been tracking my menstrual cycle pretty consistently for a while because we were trying, and so we found out before I was even to 4 weeks pregnant, shortly before that.
And how did you feel when you learned you were pregnant?
We were ecstatic, very, very excited to have a second child and, give my toddler a brother or sister.
When did you first go see your doctor about your second pregnancy?
My first appointment was around 8 or 9 weeks pregnant. That was in, would have been like September of 2022, and that was for like an initial prenatal intake appointment.
And what happened at that first appointment?
At that appointment, we had a dating ultrasound to kind of make sure that the pregnancy was there, that I was in fact pregnant, and to kind of date how far along I was. I also had some lab work done, and I met with my doctor's nurse to go over my health history.
And what, if any, complications were identified at that first appointment?
At that time, everything was progressing as expected. There were no complications.
And what, if any, issues did you have early on in that second pregnancy?
As with my first, I did not have any complications.
Did there come a time when that changed?
Unfortunately, yes, at our 20-week ultrasound, our anatomy scan.
And can you tell me about that appointment?
Yes. That appointment began as expected. Showed up to our MFM's office and had my vitals taken, and then afterwards was brought into a room with the ultrasound technician, and she began our anatomy scan.
And what is your understanding of the diagnoses you were given?
My understanding is that our baby had multiple severe anomalies that consisted of many different organ systems.
How, if at all, did your background as a chiropractor help you understand this information you were given?
I think quite a bit. One of the main diagnosis was of caudal regression, which prior to that appointment I was not familiar with. But when it was explained to me what that meant, essentially the lower portion of the spine does not form correctly. My background as a chiropractor with knowledge in anatomy made it pretty clear that that would likely affect the anatomy below the level of involvement, such as with the lower extremities, bowel and bladder, that type of thing.
And what was your understanding of the prognosis of your pregnancy?
Based on the plethora of findings consisting of a cystic hygroma, the caudal regression, the issues with all 4 appendages, all extremities, the fact that one extremity did not even have detectable leg bones, the circumference around the chest, the thoracic cavity was measuring weeks behind, less than 1% of where it should have been at that time. There were issues with the fetal stomach, with multiple issues with the fetal heart, basically every major organ system was involved. And my understanding was the severity of all of those issues led to very poor outcomes, that the pregnancy was likely not going to make it to term, but if it did, would definitely lead to a baby that had no chance of survival.
Faced with this devastating diagnosis, Dylann and her husband made the compassionate decision to end the pregnancy, considering both the unborn's condition and her own health.
At the time of that scan, we were given, all of those diagnoses, and I knew that remaining pregnant was inherently more risky than not being pregnant, and so deciding to remain pregnant with a fetus or a baby that stood no chance of survival seemed like an unnecessary risk to take.
And what did you decide to do at that point?
At that appointment, my husband and I made the decision to terminate the pregnancy and to seek out an abortion.
And were you provided any information on next steps by the doctor?
We were given options, abortion being one of them. We were also given options that if I did decide to continue on with the pregnancy, that she would recommend some additional imaging, perhaps some additional follow-ups with pediatric cardiology, pediatric orthopedics, to get a better understanding of the level of involvement. She also gave us a referral for palliative care if we did decide to remain pregnant. But after we decided that we, in the best interest of that child and of our family, after we made the decision to have an abortion, we were given resources, basically a sheet of paper that listed clinics in nearby state that may be able to assist us.
You said you were given resources of clinics in nearby states. Why not Ohio? Why not Idaho?
We were told that, and we had an understanding of this beforehand as well, but we were told that in the state of Idaho, an abortion, especially at 20 weeks, was not legal, and that my case was no exception.
So what did you do to find abortion care?
We took the list of resources that were given to us, and we came home from that appointment, and my husband started calling multiple clinics, I think upwards close to 20 different clinics in nearby surrounding states. We would come to find out that there were weeks-long waiting lists at some of them, and I did put myself on a waiting list for several clinics. Several clinics had closed their doors because of similar laws and changes in their states. Eventually, thankfully, we were able to secure an appointment in Seattle because of a last-minute cancellation that they had.
However, Idaho's strict abortion laws made it impossible to access the necessary care within the state. This forced them to seek help out of state, a process that added logistical and emotional burdens. After contacting numerous clinics, they secured an appointment in Seattle, Washington, thanks to a last-minute cancellation.
And tell us what procedure you received in Seattle.
I had a D&E procedure.
Did anyone come to your appointment with you?
No.
Why not?
Because we had to travel with my toddler. My husband had to stay back with her at the hotel and take care of her. So I had to attend both Friday's and Saturday's appointment by myself.
How did that make you feel?
Relevance. Sustained.
How did you get to Seattle?
My husband and I needed to find a flight from Boise to Seattle.
And where did you stay?
We stayed at a hotel near the clinic.
And how many days total were you there?
I believe we were there for 3 days total. 4 days, Thursday night till Sunday.
So there were 4 days between your diagnosis and receiving the procedure, is that correct?
That's correct. Our anatomy scan and our diagnoses were on Monday the 28th, and that Friday was the first part of the procedure.
Traveling to Seattle was a challenging experience. Dylann had to attend the medical appointments alone, while her husband stayed at the hotel with their daughter. She described this time as emotionally overwhelming, carrying the weight of her decision while being far from her home and support network.
I had the most, it was the worst 4 days of my life. I can't describe it any other way. Knowing that I was carrying a pregnancy that was doomed, that had no chance of survival. Each day was worse than the last. And I would say during those 4 days, my mental health got progressively worse and worse.
After you received your abortion, did you seek any other health care?
Yes, I reached out to a mental health professional for some counseling.
And what was the purpose of that counseling?
To help me work through the grief and the trauma of our diagnosis and the loss of the baby that we were very hopeful to bring home, in the same way that, I would seek out grief counseling if a sibling passed or a parent passed.
Following the procedure, she sought counseling to help process her grief and heal from the experience.
Thankfully, we were able to get pregnant again. We delivered a healthy baby boy earlier this year.
And was it a planned pregnancy?
It was.
And were you living in Idaho?
I was at the time, yes.
How did you feel about getting pregnant another time in Idaho?
Obviously we were very excited that I could get pregnant again, but guarded as far as we just weren't able to go through that pregnancy being blissfully unaware of the consequences of, potential complications that may arise. I requested additional scans to be performed earlier in the pregnancy, just thinking to myself, if we found something abnormal, if we were to have a repeat, it would make things easier for me. I would have more options. If I needed to seek out care again in another state, it would be easier to do so at 12 weeks versus 20 weeks.
And what, if any, pregnancy complications did you have with your third pregnancy?
Thankfully, none with my third pregnancy.
In 2023, Dylann and her husband welcomed a healthy boy after a smooth pregnancy. However, the trauma of their previous experience influenced how they approached this new chapter. They opted for additional early scans during the pregnancy to ensure that any potential complications could be addressed as soon as possible. The family later decided to move to Minnesota, seeking a safer and more supportive environment to raise their daughter and son.
Right now, our family feels pretty complete with 2, but I could probably be convinced to do another.
And you're still of reproductive age?
I am.
Would you seek abortion care in the future?
It would be dependent on circumstances, again, individual circumstances of that pregnancy. If we were to have severe complications again, that could potentially affect the health of the fetus or myself, then yes, I would consider it.
And where do you currently live?
My family and I moved to Blaine, Minnesota.
And where were you living at the time the lawsuit was filed?
We were in Meridian, Idaho.
Have you considered moving back to Idaho?
At this point in time, no, but my husband and I love the state of Idaho. We love physically what this state has to offer. And we have discussed that maybe potentially we could see ourselves coming back, maybe after the children are grown.
And what's the basis for waiting until your children are grown? What's the basis of waiting until your children are grown?
Relevance. You can answer.
Knowing what I went through, knowing what the state's representatives have decided is acceptable reproductive care for women. I can't imagine my daughter and son receiving that kind of messaging. I want them to have, a belief that women can make decisions about their health care. And I want, my daughter to feel safe becoming pregnant someday if she chooses to do so. And I just don't feel like that would be the case if we were raising our kids here.
Dylann expressed her concerns about raising her daughter in Idaho under the current reproductive health care laws, which she feels do not prioritize women's ability to make informed healthcare decisions. Although they love Idaho's natural beauty and sense of community, the family feels it is not the right place for them to live while these restrictions remain in place. Reflecting on her experience, Dylann revealed that her second pregnancy was later associated with an additional diagnosis. This condition could have further complicated her health if the pregnancy had continued. Knowing this confirmed for her that the decision to end the pregnancy was the right one for her and her family. Dylann's testimony highlighted the difficulties faced by families navigating restrictive abortion laws and the emotional toll of such decisions. By sharing her story, she hopes to advocate for compassionate and accessible healthcare that supports women in making informed choices about their own lives and families. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.